Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today in this video, we're going to be talking about the judgment by Ketlogetswe in a matter that was brought by Veronica Matsheka against the DIS and the Botswana police. But before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. This matter had been brought by Veronica Matsheka under the law seeking what is called a writ of Habeas Corpus. This is a matter which is brought by a person who is either in jail or has been arrested, or their family members if they can't do it themselves. And this is for the person to be taken before the court and be released because their arrest and continued detention is unlawful. In this particular matter, Veronica Matsheka said that she was bringing the matter on behalf of Dr. Matsheka, who was her husband. In answering her application, the respondent said that she did not produce any proof that she was indeed married to Dr. Matsheka, and therefore she had no right, no locus standi in law to bring the matter. In replying to this answering affidavit, Veronica Matsheka attached a copy of her marriage certificate. The respondents then argued that it was not proper for her to try and make out her case in her replying affidavit. And you can watch my video where I talk about the various pleadings to be filed in application proceedings to understand better. The judge, in looking at this, stated that in the founding affidavit she had made it clear that she was married to Dr. Matsheka, and that in giving the marriage certificate in the replying affidavit was in order to further buttress what she had already said in her founding affidavit. Therefore, he did not find any merit in this argument by the respondent. The judge then went on to look at whether or not there was any good reason for this matter to be before him. The matter was brought before him because Veronica Matsheka was alleging that the arrest of her husband, Dr. Matsheka, was unlawful, and that his continued detention was not lawful because he was arrested without a warrant of arrest, and he was detained for more than 48 hours, which is against the law at Section 36 of the Criminal Procedure and Evidence Act. The respondent, in answering this, stated that they had a good reason for why they arrested Dr. Matsheka and why they are continuing to keep him in custody. The judge, in deciding this, then stated that the law was clear. When a person is arrested, this is a violation of their constitutionally protected right to liberty. And therefore, it was up to the people that arrest and continue to detain this person to show good and justifiable reasons for the arrest and their continued detention. He further stated that in terms of Section 36 of the Criminal Procedure and Evidence Act, when a person is arrested without a warrant, and in this case, Dr. Matsheka was arrested without a warrant of arrest, then they can only be kept for a period of 48 hours. And if the arresting people wanted to keep this person longer than the 48 hours, they had to take this person before a magistrate for the magistrate to be told why they want to keep this person for longer than 48 hours, and for the magistrate to agree or not to agree. The judge found that according to what was in the affidavits of the arresting people, being the respondents, there was good reason for the arrest. However, he found that there was no good reason for continuing to detain Dr. Matsheka for longer than the given 48 hours, considering that he was arrested without a warrant of arrest. And that if indeed there were good reasons to continue to keep him, then he says the respondents would have taken him before the magistrate as is required by the law. He looked at the answering affidavit by the respondents, where they stated that this was them balancing the right to life of Tlotsokarema against the right to liberty by Dr. Matsheka. The judge made it clear that at this time it was simply allegations of the involvement of Dr. Matsheka, and therefore, even though he agreed that there was reason for the arrest, he did not believe that the issue of continued detention was justified. He found that the continued detention beyond 48 hours was unlawful, and therefore he ordered the release of Dr. Matsheka. It remains to be seen whether the matter has been appealed and whether the Court of Appeal will disagree with this position held by Justice Ketlogetswe. And in dealing with this issue of the right to life and the right to liberty, the judge made it clear that ritual killings were terrible, were completely terrible. However, in dealing with this issue, he cautioned against people doing illegal things or unlawful things, trying to justify their behavior. He made it clear that even though people's emotions in the country might be high, it was for the law to be followed and properly applied. In this instance, the law was not properly applied, in that Dr. Matsheka was not taken before a magistrate for him to be detained for longer than 48 hours. I hope you got something of use from this video. If you did, please make sure to like, share, and subscribe. And follow me on my social media, on Facebook at Botswana Thinking Law, on Twitter at BW Thinking Law, and I have joined TikTok on Botswana Thinking Law, where I put short videos on the law. And I hope to see you in my next video. Bye.